Welcome to today's AFSCME's Got Skills webinar series. Today's presentation is Duty of Fair Representation. Tom Ellett, Field Education Coordinator for the Central Region, is your presenter for today's session. My name is Shondell Day, and I'm with the Education Department at AFSCME International. I will be serving as your host for today's session. Before we begin, I would like to go over a few housekeeping notes. We encourage you to use your telephone in order to participate in the Q&A at the end of the session. Please select Use Telephone after joining the webinar and call in using the numbers provided once you sign on. Be sure to use the audio pin, which you will be given at the time in which you do sign on. All the participant lines will be muted throughout the presentation. Lines will be opened up for a quick Q&A at the end of today's session. If you have questions along the way, please enter them using the chat feature to put them into the queue. We will stop at some sections to go over answers to your questions. Please take the survey at the exit of this webinar to receive your certificate of participation. You will be sent a certificate by the close of the next business day. Please be reminded that this session will be recorded. On the right-hand panel, you will see a hand icon next to your name. If you can see that hand icon, I would like for you to test this tool by clicking on the icon to raise your hand. Does everyone see that? The hand icon next to their name? If so, please click on it. Okay, great job. Okay, and you can just click it again to lower your hand. And at this time, I'm going to thank you again, and I'll now turn this session over to Tom.
Hello all. This is Tom Ellett, and I want to thank you for joining me for this webinar on the duty of fair representation. If at any point you want to join the conversation with a question or a comment, just raise your hand. Shondell will unmute your line and we'll call on you, and then you can join in the conversation here. Okay? Let's go ahead and get started. Today we're going to talk about the duty of fair representation and what that means for you as a steward representing your coworkers. By the end of this module, you will know your legal obligations under the duty of fair representation, and we'll identify some best practices for representing your coworkers fairly. As a steward, you're going to encounter situations where you're asked to represent someone that you might not think deserves representation for whatever reason. Maybe she refuses to join the union, or maybe he's not a very good worker, or maybe you've had a personal conflict with that person. You're going to ask yourself, do I really have to represent this person? Raise your hand if you've heard the phrase duty of fair representation before signing up for this webinar. Good. I see some folks have found the hand icon over on the right-hand side. Okay. Well, a good number of you are already familiar with this term, duty of fair representation, but some of you are not, and even those of you who have some familiarity obviously have some desire for some additional information. So let's come up first with a clear and concise definition that covers all of the bases. The definition our attorneys like best is this one. When the union is won the right to be the exclusive representative of workers in a bargaining unit, it also has the duty to fairly represent all employees in that bargaining unit, regardless of whether they are members or non-members. Does everyone think that that's a pretty clear definition? If you do, raise your hand for me, please. Good. Most folks like it. Is there anybody that doesn't think that's a particularly good definition of the duty of fair representation? Okay. Some folks feel like there's something more that needs to be said. Well, let's go through it bit by bit and see if that doesn't answer some questions folks might have. Again, if at any point you want to join in the conversation with a question or a comment, raise your hand, and we'll try to make sure we get you included here. So let's take a closer look at what that definition says. First, the duty of fair representation comes from the union status as the exclusive bargaining representative. Now, this usually isn't written into your state labor laws. It's not included in the National Labor Relations Act, but it's come down from court cases over the years that basically says because only the union can deal with the employer on things like wages, benefits, and conditions of work, we have to represent everyone. And we have to represent everyone fairly. We can't provide good representation to some and poor representation to others. And it doesn't matter whether they're members of the union or non-members. Okay? So right about now, you're probably saying to yourself, do I really have to represent non-members? Yes, our definition makes it pretty clear that we can make no distinction between members and non-members. And it doesn't make a difference if they are fair share fee payers, paying most of the dues amount, or, as in right to work for less states, they are free riders that don't pay anything at all. How about those members that are opposed to the union leadership? We must also treat those coworkers just the same as any loyalist or any member of the union leadership. And how about your worst personal enemy, your arch rival at work? Again, you can't treat them any differently than you would treat your friends. However, you might want to have another steward represent that person, even if just to avoid the appearance of a conflict of interest. Okay, I'm going to take a quick peek. I see someone has a question about what is the court case that I cited. It's not a particular court case, again, because we're dealing with the National Labor Relations Act, which is for private sector employees, as well as basically 50 different state labor relations acts. There is not one particular court case, but again, this is the way the courts have interpreted the union's exclusive nature of its relationship with the employer, and because it's exclusive, we therefore have to represent everyone. Okay? If we want to talk more about that at the end, we certainly can. Thank you, Lillian. All right, so how do we demonstrate that we're treating all bargaining unit workers fairly? How do we fulfill our duty of fair representation? Well, in order to fulfill our legal obligations to our coworkers, we need to fully investigate potential grievances that come to our attention, and then evaluate the complaint based solely on the merits of the case, not the merit of the grievant. If appropriate, you should file the grievance within the contractual time limit, keep the grievant informed about the status of the grievance as it goes through the process, and if the issue is not pursued, or if the grievance is dropped at any step of the grievance procedure, notify the individual of the reasons for the union's action or lack of action. And if your local has an appeals process, let the grievant know what that is as well. Okay, so you've investigated the individual's complaint. Do you have to file grievances over matters that are not violations of the contract or past practice? No. If your objective analysis is that the contract has not been violated, you do not have to file frivolous grievances. If you filed a grievance but didn't win it at the lower grievance steps, the union doesn't necessarily have to take the case all the way to arbitration, as long as the decision to not proceed is based solely on the merits of the grievance. Who should make that decision? The best practice is for there to be a grievance review committee or another leadership body that reviews cases and makes those decisions, analyzing the merits of the grievance without bad faith, without discrimination of any kind, and not in a perfunctory, careless, or hasty fashion. Okay, we're going to take a look at a situation faced by a group of local leaders and see if this local union has any vulnerability to a DFR complaint. You might want to take some notes during this video.
All righty, I guess we're all here.
So what's with Marie Crenshaw's grievance? Where is it now?
It's been withdrawn. You want to tell her?
Withdrawn? Who withdrew it? That was an important grievance, and it looked like a clear-cut, easy-to-prove violation of the contract.
It's my decision to make, and I made it. The city's already been notified. You want to tell Crenshaw?
Why are you pulling a strong grievance? I know the woman is a pain in the butt, but her rights are definitely being violated, and her whole department is watching to see what the union is going to do. This is not right, George.
We're going to argue about this all day. We don't have time for this, so withdrawn is withdrawn.
Well, since we're talking about grievances, I'll just inform you that the Maynard Brown and the Marie Suarez grievances are also withdrawn. The Bill Jones case has been sent in for arbitration.
Well, thanks a lot. Who decided that? I thought we all discussed sending the Brown grievance forward, didn't we? And the Jones grievance is a loser. Why are we even wasting our time on that one? And besides, we just got a request from the council director for each local to set up a grievance review committee to have these decisions made in a fair and open manner. And it sounds like we're going in the opposite direction.
This is our local. I don't care what the council director says. If we get sued over a grievance case, they have to defend us anyway.
Yeah, the council director isn't really running our local anyway. They work for us.
Calm down, Logan. But seriously, what about the Jones grievance? You surely can't think that thing belongs in arbitration.
Hey, it's all done. Jones has been a strong union supporter for a long time.
A strong supporter of you mean?
Please, can we move on?
Okay, so did anyone see any problems facing that local union leadership? If you did, raise your hand. Okay, a number of you do believe that this local union has some potential problems. We're going to open up the lines a little bit. And Benjamin Ritchie, you think that this local has some problems. What did you notice?
Between themselves, even as I don't know if this is a council or the group of stewards, it sounds like there's a lot of personal background issues that are making them unable to be objective when they're working with each other.
Yeah, I think that's absolutely right. That obviously there is some personal agenda going on here, and that they're not really being objective when they're evaluating grievances in terms of whether to pursue them or to not. How about Crystal Shiflett? Crystal, did you see a problem with this?
I do. It just seems like the one gentleman, he decided he was going to make decisions on his own and not take in the rest of the team's agreements to pursue or not to pursue some of the cases that they already discussed. And he was calling it his union and not their union. And he was also not being very professional, and he was also knocking down, you know, the higher ups in the union, and that's not any way to be dealing with anything, especially in that type of environment.
Sure, yeah, not very democratic, that's for sure, and as you say, not particularly professional, kind of acting in a unilateral and arbitrary way, absolutely. Well, okay. It sounds like, though, a number of you did notice that that this local union does have some problems with the way they're operating. Let's review some of the particular cases they discussed. So the first one was this Marie Crenshaw, whose grievance, it sounded like, had some merit, that the local president decided to drop it, and perhaps the reason was because she's a pain in the butt. It's not exactly clear, but it did not sound like the reason why her grievance was being dropped had anything to do with the merits of the case. Another case, Maynard Brown, that grievance was also going to be dropped. And again, it sounded like the leadership had earlier decided it had merit, it deserved to be advanced, yet the local president was withdrawing that one as well. But then we have Bill Jones. His grievance is headed towards arbitration, even though it sounds like it was not a very good case. Yet Bill was a strong union supporter for a long time, and it appears he's probably a friend of the local union president. But again, you cannot show favoritism even towards folks who are good, strong, long-time union members. And then finally, I think a number of you touched on it in your comments as well, there really is no functional democratic process to review grievances and to make a determination whether to pursue a grievance or not. And so therefore, there are a number of reasons that this local might be vulnerable to a duty of fair representation complaint. Okay, so any questions about the material up to this point? Any concepts that are not clear to you? If so, raise your hand. All right, very good. It looks like most folks have got the basic concept. So let's just test that a little bit. Let's do a skills check. A couple handful of true and false, true or false questions. The first one, because of the duty of fair representation, the union is required to pursue any grievance a worker wants to file regardless of its merits. True or false? You can answer by clicking on that button right next to the answer you want to choose and then pressing the submit button. Great. Okay. Most folks got the answer that it is false. Simply because a member wants us to file a grievance does not mean that we have to file the grievance. Again, part of our job is to make an analysis of the facts, determine whether there has been a contractual violation or a violation of past practice, and then on that basis, either file a grievance or not. But if there is no contractual basis for a grievance, we do not have an obligation to file a grievance over every complaint. Okay, question number 2. In a bargaining unit represented by a union, the union is obligated to appeal every single grievance to arbitration. True or false? Very good. Most folks have got the correct answer that that is false. Again, if the union in its analysis determines that a grievance does not have sufficient merit to go all the way to arbitration, even the fact that we already filed the grievance and we pursued it at the lower steps of the grievance process does not obligate us to take it all the way to arbitration. All right. Next question. If a non-member approaches a steward with a meritorious grievance and the steward tells the worker to get lost until you sign a membership card, the union could be successfully sued for breaching the duty of fair representation. True or false? Very good. The correct answer is true, that you cannot predicate the pursuing of a grievance on whether a coworker will or will not sign a union membership card. Okay, next question. If a steward, acting in good faith, mistakenly files a grievance late, this violates the union's duty of fair representation. True or false? We have a bit of a split decision here. While mistakes do happen from time to time, provided that the steward has acted in good faith, then they have not made the local union vulnerable to a DFR complaint. Now, if the steward is acting carelessly or acting with bias, then yes, failure to file the timely grievance very well could place the local in jeopardy. But again, the key phrase here is acting in good faith. As long as the steward's acting in good faith, even a mistake such as failure to file a timely grievance does not jeopardize the local union. Okay. One more question. The union should keep a written record on every grievance case. True or false? Great. 100% true. That's right. If for no other reason than in the event the union is accused of failing to represent a bargaining unit member fairly, the records of previous grievances very well could be determinative as to whether the union can demonstrate that it treats everyone fairly or not. So very good. Great job, everyone. So that's our legal duty of fair representation. And failure to abide by it could result in costly lawsuits or labor board charges for the union. But I want to leave you with a suggestion that there are good organizational reasons to do these things, even if there weren't legal consequences. Providing fair and equal representation demonstrates the union's commitment to equality and boosts the union's reputation as an organization that protects all workers' rights. Extending everyone's contractual rights and benefits maintains the integrity of the contract for all, and it might even result in some non-members joining. In a word, fulfilling our duty of fair representation is good organizing. All right, so basically we're talking about the golden rule, represent others as you would like to be represented. If anyone has any questions at this time, raise your hand, or you can type it into the question box if you're unable to join us audibly. And we'll see if we can't get you some answers. Gabriella, let's see if we can get your question.
Hi.
Go ahead.
I was called up to represent someone yesterday as a shop steward, and
yes.
The manager that I had the disciplinary hearing with misrepresented the nature of the hearing and essentially muzzled me throughout the hearing, and I wondered if that would make me subject to a DFR complaint, or if that would be something that I would have to challenge myself.
Sure. Well, the short answer is no. The supervisor's actions would never place you or the union into any vulnerability with respect to a DFR complaint. And I didn't make this clear to folks before, but let me do it now. The vulnerability to a DFR complaint does not rest with the individual steward. So in the event that you're concerned that you somehow have some personal liability, in the event that a bargaining unit employee has made a DFR complaint, that liability does not rest on you. It rests on the union, which is still, of course, very serious, but you do not have personal liability. With respect to the supervisor mischaracterizing the nature of the meeting, again, that won't have any impact with respect to your providing fair representation. It could be a bigger problem to take up with the management, but as it relates to DFR, no, it does not have any impact on you. I'm going to call on Lillian Hawkins. Lillian, can you ask us your question? I'm not sure if it appears you have a microphone, but perhaps you don't.
Can you hear me
now? Oh yes, now I can hear you. Great.
Okay, good. Thank you. Hi. So I have a question. We have a current investigation going on where a group of employees feel like another represented employee is bullying. And so this other employee that's doing the alleged bullying is also in what we call an acting management position. So when the manager calls in sick, or the manager needs help for the day, we have these acting manager positions where a union member can fill this position and do accounting and, I guess do, so they're in an acting position. So we have gone in with HR and our staff representative and my vice president, and we went into the location and we met with half of the people, half of the members there, and so we're doing our other half this Thursday. So my question is, if it comes to light in this investigation that there is some bullying happening on our union members, from our union member in this acting management position, how would we proceed and not be in a position where we would have a duty of fair representation issue?
Oh, that is an excellent question. And it happens not just when one of our members is temporarily acting in the role of management, but sometimes we have bargaining unit members, union members who are having some kind of conflict, whether it's bullying or could be sexual harassment, could be another form of discrimination that's taking place. And, the question arises for us, so how do we fairly represent both employees? Do we have to take sides in the issue? And the answer is no, we don't necessarily take sides. But what we do is we provide separate representatives for each of the parties. So if it's a two-person conflict, we'll assign the steward to one person, we'll assign the steward to the other. And hopefully the stewards will also work together, because the stewards, even throughout this process, should not see themselves as adversaries, where they need to represent one employee over the other, but provided that they are ensuring that the members are receiving their due process. That is where the union's duty of fair representation lies. So, for example, let's say we have a situation where one member is sexually harassing another member. We represent both. We ensure that the accused gets his or her due process as well. But we don't have an obligation to, if our investigation demonstrates that in fact the member has been engaged in the inappropriate conduct, we don't have an obligation to take that case all the way to arbitration. I mean, there are times, I know it's hard to believe, but there are times when our brothers and sisters are wrong. And our obligation is to make sure that they are treated fairly, not, though, that they're exonerated for wrongdoing that they may do. Okay, I hope that answers that question. I'm going to take a look at one of the written questions we have here, and a brother from my state of Wisconsin asks, does this apply in a state like Wisconsin where we now have an employee handbook and no contract? And also, must the union represent a non-union member in a disciplinary action? The question is whether the union is the exclusive bargaining representative. So, for example, in Wisconsin, we have a number of situations where we have unions in the workplace, yet they no longer have the exclusive bargaining representation of those employees. So in those circumstances, we do not have the duty of fair representation because we don't have an exclusive relationship with the employer. As I mentioned, though, there might be good reasons to represent everybody, even in those circumstances where you don't have to, good organizational reasons. But again, in most states where we have a local union in place, they are the exclusive bargaining representatives and therefore do have this duty of fair representation. And your question concluded with, Also, must the union represent a non-union member in a disciplinary action? Again, if you're talking about it in a situation where we are the exclusive bargaining representative, yes, we must represent non-members in disciplinary actions just as we would a regular card-carrying, dues-paying member. Okay, another question. What can you do with an employee who is constantly insubordinate, has been warned to improve, but no success? Again, our obligation is to ensure that people are treated fairly, not that people are allowed to flaunt the rules or engage in, any otherwise inappropriate behavior. So our obligation is ensure that they've got their due process rights, make the employer investigate the allegation, make the employer prove the allegation, ensure that the employer is applying the rules consistently and that the discipline is appropriate for the work rule violation. If the employer is doing all those things, our obligation is not to get the employee off at any cost. Okay. Another question. Do you mean agency temps when you say non-members? No, what I'm talking about non-members there is anything from a fair share payer. I guess in some locations you might call them agency fee payers. Now this is not the same thing as a agency temp that might come from a temporary agency. But a fair share payer is a person who has chosen not to join the union, but because of the laws in your particular state, has an obligation to still pay their fair share of the costs of union representation. So that type of person is a non-member, even though they're paying most of the dues. In a right-to-work state, you have people that don't have to join a union and don't have to pay a dime. Yet we still have that same obligation to represent those people. It's outrageous, I know, but unfortunately that is the way it is. Okay, well that's the written questions. I see, I don't know, Benjamin, do you have a question? I'm unmuting your line now.
Yes, I had a question about with the obligation to inform of updates and notify a resolution. Is there a standard timeline for what's considered reasonable with that?
No, there is no hard and fast rule. Again, I mean, apart from the duty of fair representation, there's just good organizational reasons to let folks know what's happening with the process. But again, letting them know where their grievance is in the process, and if it doesn't advance, letting them know why it doesn't. More is just good practice to ensure that there's no allegation that the union has acted carelessly or has acted arbitrarily, because we can demonstrate, look, we would not be notifying the person if we're acting in an arbitrary or a careless way. Are there any other questions? Wait, I do have one more written question. I am a chief steward. During a grievance filing, I had to excuse myself due to an extreme personal confrontation just prior to the grievance. The confrontation involved the future grievance had attacked the union and my role in the union. Was it okay to pass my duties off? If what you are suggesting is that you got somebody else to handle that person's case, that's perfectly fine. If you're suggesting, though, that you told that person, hey, look, you don't like the union, then you can just fend for yourself. If that's what happened, that's not okay. But again, because sometimes people that we're asked to represent are, for whatever reason, we have a personal conflict with them. It may not even be related to the union. And in those instances, we ensure that somebody else provides them the same level of representation that anybody else would get. It does not necessarily have to be you. Okay. So Ben has followed up his question with this. We have had to constantly ask for updates in a grievance we have filed with our union. At what point does this failure of duty representation? You know, again, there is no hard and fast rule that the union should be providing you with that information as it goes through the process. But, you know, sometimes grievances take a lot of time to resolve, and it's not always, you know, we're not always able to resolve them within the time frame that most folks think they should be. Okay. Well, I see that that we have no hands raised and we have no further questions. So with that, I want to thank you for attending this webinar. I thoroughly enjoyed it, and I hope that you did too. For more information on the duty of fair representation, see the Ask Me Steward Handbook. On pages 42 and 43, you'll find some additional information about the duty of fair representation. And if you have any future questions, concerns, or doubts in the future, don't hesitate to contact your local leadership or staff. Again, I thank you for attending tonight, and good night.